Good morning, everyone, and thanks for joining in our expert series webinar on decoding the EU AI regulations for tech entrepreneurs today. It's a Sunday morning, so I can imagine it's hard for people to wake up early. But anyways, today our host is Kshitiiz Verma, as you can see on this presentation. And Future and AI is India's largest and fastest growing AI community with over 160,000 members. We make a lot of content on Instagram and LinkedIn. If you have checked us out there, I'm pretty sure most of you have. And we also have a pretty big newsletter, if I say so. A Future and AI has been founded by Nivedan Rathi, as you can see him here. He's an IIT Bombay alumnus, an ex-founding member of several tech startups, and a responsible AI adoption evangelist. Our today's host is Kshitiiz Verma. He is an associate professor at J.K. Lakshmipat University, specializing in computer science, deep learning, and law. His academic journey is adorned with prestigious accolades: a PhD in telematics engineering, a bachelor's degree in computer science from IIT Kanpur, and a law degree from Rajasthan University. His current research areas include enhancing justice access in India. He is a Sir Ter Fellow and teaches large language models and AI regulation through his YouTube channel. He is also on the advisory board for EU AI Act Toolkit. The project is being executed in the University of Cambridge. He will now commence with this presentation. The stage is yours now, Kshitiiz.
Okay. So can you hear me?
Yeah, you are audible.
Okay. So thank you for the kind introduction. And I'm passionate about law. So I've done a law degree in general, and I'm passionate about computer science too. So we'll start with that. This is a QR code that takes you to my YouTube channel. This particular presentation is just for maybe, I don't know, 90 minutes. But on my YouTube channel, I have created, I've actually recorded the courses that I have taken at the university. So this last semester, we talked about large language models. We also talked about regulating AI, where the lectures are in much more detail than what we'll have it here today. Okay. So topics to be covered today broadly will be this. We'll be talking about importance of AI regulations, because see, AI being a buzzword, people care less about what can be done, what should be done, what is ethical that can be done, and so on. So these philosophical questions are usually ignored by many tech entrepreneurs. So we just want to build systems that work, right? But we don't really take a morality, a ethical part of it, that how much of it should be allowed in the society and so on. So we'll be talking about importance of AI regulations and legal principles underlying the AI regulation in particular. So when I say legal principles underlying AI regulation, I actually talk about EU AI Act, okay? And there they define this risk pyramid. Then I'm not sure if I'll be doing this, but this is a debate in itself, because you don't really know how do you define AI, even in the tech sector. So giving a legal meaning to it, that will create a legal certainty. This is probably one of the this has been one of the most challenging things to come up with this AI Act, because till now we are not confident whether the definition that EU AI Act actually gives to AI, whether that is unanimously agreed or not. So in my knowledge, that thing is not unanimously agreed on, but in the end, you have to agree on something. So this is what we have, but we have not seen any legal implications, as there are no cases as of now. Then we'll talk about subject matter and scope, terminology, and requirement for high-risk AI systems. I think this is the most important thing that is for tech entrepreneurs, right? So this part is the most important thing for tech entrepreneurs, this part. Now we'll see direct impact on product development businesses, obligations of providers and deployers. What do these terms mean in this AI Act, and what are their obligations? And then some measures in support of innovation too. So maybe we'll see, I don't know, a little bit of that too. So concern versus excitement about AI. This slide dates back to 17th of, this particular figure that I have taken from dates back to 17th of March 2022. So fairly old, 2 years old already, but still I believe that these numbers would only, so for example, Americans lean toward concern over excitement when it comes to the increased use of AI in daily life. So if you see here, more concerned than excited, more excited than concerned are less than half of what more concerned than excited is. Now, I believe, so this is pre-chat GPT era. Now, I believe that once the power of, large language models has been unleashed, I think this number will further increase. And I don't know, maybe this might decrease a bit. I don't know, speculations. But what I'm saying is, my conjecture is that this number might have increased once we have seen more powers of AI that we have seen through LLMs. So the thing here is, people are more concerned than excited because it might infringe our rights in some sense, because technology gives whosoever controls it so much power that is beyond imagination. And then there is something called automation bias. So there is an automatic thing in that we humans like to believe that if computers, or for that matter, any machine. So if computers have done it, it must be right. And as a corollary of that, if AI has done it, it must be right too, right? So, but those who are working in this area, those who are scholars in AI, they know that AI is still emerging. So it is not yet, a foolproof kind of thing. It is still emerging. All the techniques that we are trying to employ, they are just ad hoc, right? You try some model that works, that gives you test accuracy on something, fine. So we are mostly still performance based. So this is the metric that you will see in almost all papers. Nobody really cares about things like explainability, ethics, and so on. There's a long list. There's a lot of work and research on bias now. Okay. So, but performance still happens to be key thing. I mean, in more than 80% of the papers, you will just see the performance evaluation of systems, and other dimensions, almost nothing. So as you can see through this news, breast radiologists impacted by automation bias when using AI. So when you go through this particular article, here they say that radiologists, when they were told that AI is, for example, saying that in this particular CT scan, AI detects there is no cancer. So radiologist will also say there is no cancer. If AI says there is cancer, radiologist will say there is cancer. In a nutshell, meaning that they won't apply their own mind, because AI has some kind of perception in everyone's mind. Radiologists are radiologists. They are not trained to be AI experts. Because of automation bias, they believe that whatever AI is doing, that must be right. And hence, if AI says that in this particular CT scan image, there is a tumor, then there must be a tumor, and vice versa. But this can have a lot of impact, as they talk about in this news. So automation bias is not just for laymen's, like those who have no knowledge of AI and are not so much in technical and science sector, but those who are experts in domain, even they suffer from automation bias. So that is the key thing, at least tech entrepreneurs should care about, because once they build a system, most of the people would like to believe that it works the way it should, even when it is far from doing so. Okay. So maybe I'll mark this slide as a star. So if you ever happen to go through these slides, this is one of the important slides. Now, exponential growth of AI versus legal inertia. So we know that the number of attendees at AI conferences have skyrocketed. We know that the startups developing AI systems have skyrocketed. So all of this, see like an exponential curve. Enterprise application AI revenue has skyrocketed. So the speed at which AI is evolving gives too little time for the society to respond. Legal process is a very slow process, and it should be. It should not respond to outliers. It should not respond to, some sudden jumps or sudden downfalls. Legal response has to be slow, but how slow? So the speed at which AI is evolving and the speed at which, legal jurisprudence grows, there's a huge gap. So AI is evolving fast, has a lot of potential to harm human beings. So law must catch up. Law cannot be slow in the traditional sense. It must accelerate itself so that the gap between the advancement of AI and the legal framework, that should not be too much. So this exponential growth coupled with insufficient checks may be catastrophic. And this is what we'll talk about in the next few slides. So AI can have a negative impact on health. So AI chatbots like ChatGPT giving wrong medical advice. So man dies by suicide after 6 day chatting with ChatGPT like chatbot. So this person started talking about on the issue of climate change, and the conversation about climate issues of the world turned confusing and harmful, prompting him to end his own life. So we already have at least one case where interaction with large language models has ended up, taking one life. And this is March 31st, 2023. AI bots like ChatGPT can now influence people in taking decisions related to life and death. So as a human being, maybe I have some things I don't want to talk to someone else. I start chatting with ChatGPT. I start taking advice from it, and it can get as serious as we want it to be, right? So instead of going to a professional, we start seeking help from these large language models, which they were, mind you, never designed to be so. So a large language model is designed to predict the next word, mod RLHF. So it is supposed to be helpful. So all these language models are supposed to be, helpful, harmless, and honest. And we know that it is not the case every time. So whenever they, not follow any of this, we call it that they hallucinate. Right? The fourth H that comes into picture. So LLMs are designed to have these three H's, but they end up having this H as well, and which happens to be one of the very harmful things. So we have talked about health. Now we talk about safety. So what happens if, for example, AI components are used in railways? So if railway or airplanes suddenly start using AI that have not undergone enough checks and balances that they should have undergone, because given the gravity of their use, given the impact that they can create, or if you start using AI somewhere in the supply chain of water, gas, electricity supplies, if there are no sufficient checks and balances, this can be catastrophic, right? Because let's say if I make a game called Candy Crush, I use AI there, okay, it does not matter, hardly harms anyone. But if I start using AI in railways, aeroplanes for whatever reasons, and if my system has some bug or error, then that can become catastrophic. So it can have negative impact on safety of human beings. Violation of fundamental rights, artificial intelligence and gender equality. So we have seen kind of examples where ads of Google, Facebook, they are the same. So already see a lot of bias that violates right to equality of human beings not just this right, but many other rights too. So that violates fundamental rights of human beings. Potential to impact democracy. So it's possible to generate huge amount of misinformation at virtually no cost. This was not true before. It was not possible to generate huge amount of misinformation. And if you are generating huge amount of misinformation, it will come at a very high cost. It has changed a lot now. Huge amount of misinformation and virtually at no cost. So it has an impact, an era in which nobody trusts any information coming from anybody. So again, May 14, 2023, AI-generated disinformation poses threats of misleading voters in 2024 election. And I don't remember, but I've somewhere read that in 2024, elections are due in 60 countries worldwide, including India, I think US, and so on. So disinformation is believed to play a big role in 2024 elections. And unless there are any legal checks and balances, it will be very difficult to curb misinformation. AI muddies Israel-Hamas war in unexpected way. So fakes related to the conflict have been limited. So there have not been too much fakes and largely unconvincing. So that is fine. What is not fine is their presence has people doubting the real evidence, the real evidence. So even if a real evidence comes to me, people start doubting because they have seen a couple of fakes earlier. It threatens rule of law, denial of genuine evidences in a court of law. Because, I can always come and say, whatever video you are showing me is fake AI generated, whether it is real or not. So it has a potential to deny or help in denial of genuine evidences in a court of law. A University of Washington prof says. Serious impact on the environment. We know from what was publicly announced that ChatGPT training has cost $100 million. It was trained for 100 days on 25,000 NVIDIA A100 GPUs. And the server with these GPUs use about 6.5 kilowatt each. So 6.5 kilowatt, I can say roughly 4 1.5 ton air conditioners. So 4 air conditioners, now 25,000 such servers. So 25K, that gives you 100K ACs, 1.5K each, 100K air conditioners, 1.5K each, running for 100 days. This much power was consumed in training ChatGPT. So it has a serious impact on environment as well. And the estimated energy consumption of GPT-4 query is this much. This all leads to increased e-waste because GPUs are being, they are very lucrative thing these days. Everybody wants to buy them, but where will we waste all these things? So a lot of environment related issues are also related to AI advancement. Some applications of AI in sensitive areas. So AI in recruitment and selection. I've seen many people doing this, many companies doing this. Now, unless this is regulated by law, there are no issues. But let us see what happens here. So this is a news from 2020, University of Texas. The news title is University revealed it killed off its PhD applicant screening AI. So it killed off its PhD applicant screening AI just as its inventors gave a lecture about the tech. So university wanted to deploy AI in the screening of PhD applicants, but as soon as the inventors gave a lecture about the tech behind it, the university revealed that it has killed off that AI because they found it was biased against the non-natives. Okay. So fairness, bias, they are probably more important than just performance of AI systems. And as a tech community, what we care about is these performance matrices. My accuracy is, in fact, I read the news today that 8,000, so US police has used a software called Check Cyber or something like that in 8,000 cases, and it was a proprietary software. None of it has been established. So many accused have been lingering around, and it is a mess. So maybe I can share you the link of that news. I just read it maybe 1 hour ago, and it is a very recent one. Today is 5th of May. The news is of 3rd May. So AI in recruitment and selection, it has to be carefully done because it can be biased. AI in policing has to be carefully done because it can be biased. So white male is shown low risk, black male is shown to be at high risk, whereas Forget was rated low risk after being arrested with cocaine and marijuana. He was arrested 3 times on drug charges after that, right? But a non-criminal background black person, right? Even they are classified as high risk. So there are there are a lot of issues with AIs. Predictive policing, where police wants to predict who will do the crime, where will do the crime, and so on. Predictive policing poses discrimination risk, think tank warns, and these are pretty old news. In USA, police has been doing this for last maybe 10 years or so, and already voices against the use of AI in policing. So hundreds of mathematicians are boycotting predictive policing. LAPD pioneered predictive crime with data, but many police don't think it works. So AI in policing again has to be taken seriously. It has to be taken with a lot of caution. Supreme Court of India's vision to use AI. Supreme Court wanted to translate its constitutional benches discussions, transcribe them, and translate them. It impacts rule of law because the Supreme Court constitutional benches, the rulings of Supreme Court constitutional benches are binding on all courts in India, including the Supreme Court, where the bench size is lesser than the said constitutional bench. And we know Anil Ambani's case, right? So just one word not was dropped from the judgment, and it led to the termination of 2 employees in the Supreme Court. So we know legal judgments, legal things can be so sensitive that we don't really want to take a call of this kind that my system is 98% accurate, because maybe those 2% that we are leaving, maybe that counts. It counts. How are we computing accuracy and so on. So various legal instruments for regulating AI. There have been universal guidelines for AI, OECD AI principles, G20 AI guidelines, UNESCO recommendations, EU AI Act. This is the one that I will be discussing, and so on. Executive. So this is the US President Order on secure, safe, and trustworthy development and use of AI, and so on. So there are a lot of it. India, from what I know, they have issued just 2 advices, 2 regulatory advices. One was on 1st of March this year, and another was on 16th of March this year, where they say that for deep fakes, the platforms will be responsible. But from what I understand, it has no force of law, because it was not, it just came from meeting, right? But no parliament law, no state legislature law, so that has no force of law as such. So I'll take a break here, and then I'd like to take some questions if there are any, because then we'll go to the details of the EU AI Act itself. All right, so then we proceed. So EU AI Act. Now, EU AI Act is the first one to, the first comprehensive law. China is already regulating some parts of AI, but EU AI Act is first law, and it was adopted by EU Parliament on 13th of March 2024. It is not yet published in their official journal. Once it gets published in their official journal, it will be, so 20 days later, it starts, it is enforced basically. And then there are various timelines for different kinds of provisions there. But they expect it to be published somewhere in end of May or maybe June. So maybe in a month, it will be published in the official EU journal. What is the purpose? So the purpose of this regulation is to improve the functioning of the internal market. So I think this is important. I mean, I'm pretty sure maybe it has not come right now, but it is very soon about to come. And in particular in Europe, a lot of talks about this are going on. AI, it is being regulated. This is a huge document that I've already shared with you. I mean, the way it looks right now, it is 458. But a consolidated document will look somewhere around 200, 250 pages. So the purpose of this regulation, the EU AI Act, is to improve the functioning of internal market. This basically means the EU market. Okay? And promote the uptake of human-centric, trustworthy AI, while ensuring a level of protection of health, safety, fundamental rights enshrined in the EU Charter, including democracy, rule of law, and environment protection. So these 6 things I have already talked about in my previous slides, where we talked about newses that covered impact on health, safety, fundamental rights, democracy, rule of law, and environmental protection against the harmful effects of AI systems in the union and supporting innovation. So in the union, and they also don't want to stifle innovation in Europe, but there are a lot of arguments against this. So there is a study that says the compliance cost of EU AI Act is 300k euros. That's a huge cost, and of course it will have some impact on innovation as well. So for example, the voices that are against EU AI Act in EU are that if you have such a high compliance cost for EU, I mean for the AI Act, then why would an entrepreneur wish to make a startup in AI? And that will stifle the innovation, AI innovation in Europe. Subject matter. So what EU AI Act actually covers? This regulation lays down harmonized rules for placing on the market, putting into service, and the use of AI systems So I'll talk about these terms in detail. They are defined in the Act. So this regulation lays down placing on the market, putting into service, and the use of AI systems in the European Union. They prohibit certain AI practices. So just blanket ban on those AI applications, specific requirements for high risk AI systems and obligations for operators of such systems. So again, we'll talk about it. They define it in the Act. What are these operators? Basically, this operator is one word for all the people in the supply chain of AI applications. Harmonized transparency rules for certain AI systems. Transparency rules, so they are not high risk, they are not prohibited, but the users should know that these outputs are coming from AI and not from a human being. Harmonized rules for the placing on the market of general purpose AI models. This came after the release of, this was heavily debated after the release of ChatGPT in November 2022. So the first draft of EU AI Act was made public on 21st April 2021. And it has taken them 3 years, almost 3 years, because it was passed on 13th of March 24. So a lot of debates have taken around this. So, and still it's very vague. Rules on market monitoring, market surveillance, governance and enforcement. So the Act also provides about this, but this is something we'll completely ignore, not even talk about them. Measures to support innovations with a particular focus on SMEs, including startups. So I'm not sure if I'll get time to do this, but we'll see. Risk pyramid. So EU AI Act basically classifies AI applications in this vertical risk pyramid, where in this particular area, they cover prohibited AI. So those AIs that EU values, so EU simply thinks according to their values, they must be prohibited. That's it. Okay. Not all these that are prohibited here are prohibited everywhere. For example, so EU prohibits social scoring. EU prohibits social scoring in general. I don't know about in general, but using AI for sure. But China is actually doing it. So it's not that whatever is prohibited in EU will be prohibited everywhere else. Depends on the jurisdiction, the country. Then regulated high risk. So those are prohibited. Nobody can make those AI systems, full stop. There is no other thing, right? Once prohibited, it is prohibited. This next level comes high risk. So in this case, those AI that are high risk, they will be regulated. And it won't be wrong to say that AI Act actually covers just, most of AI Act is all about this part. AI that are high risk and are actually rewarding, but they have to be regulated well. They can't simply be put on the market or put into service as their provider thinks. So there has to be some checks and balances that this particular AI Act brings about. This is the main topic of our discussion today. Then limited, transparent, limited risk. So not every, so what they believe is maybe, so legislators believe no more than 15% of the AI applications will fall in this area. Okay. And most of it will fall here, because let's say if you are a game developer, if you are making Candy Crush and if you are making use of AI in that, there is no apparent direct harm. So it's a low and minimal risk AI. Whereas if you want to do deep fake, so deep fakes, they follow in this category, where those developers who are making deep fake, right, they are supposed to tell upfront that this is a AI generated content is not real. Okay. So transparency, this is what it means. Transparency to users that whatever they are receiving as an output is a AI generated content, be it text, be it video, be it audio, whatever it is, be it image, whatever it is generated by AI. All right. So now main actors in the EU AI Act. And this is where, our topic of discussion starts, that how is it important for entrepreneurs? So Provider means a natural or legal person, public authority, agency, or other body that develops an AI system. So I'll underline things that are of importance to us. Provider means a natural or legal person. So it does not mean, companies will fall here. Okay. So a natural or legal person, I don't have to be a company. Even if I'm just a person, a natural person, that means a human being, right? Even if I'm developing an AI system or a general purpose AI model, or that has an AI system or a general purpose AI model. And for us techies, all this boils down to, developers of AI. So, and places it on the market. So you make it available on the market, place it on the market, or puts the AI system into service under its own name or benchmark, whether for payment or free of charge, right? So provider, this is a very complicated definition, but provider means those who are developing AI system, developers of AI system. I don't have to be, an important thing here is I don't have to be a company. I can be a single person, a single human being doing it. That also makes me a provider. A provider can also be a public authority, agency, or other body, but our concern is just this, that I'm a company or I am a person. So provider is basically developer of AI. Deployer means a natural or legal person, public authority, agency, or other body using an AI system under its authority. So using an AI system under its authority, except where AI system is used in the course of a personal non-professional activity. So if I am using AI system in the course of a personal non-professional activity, that does not make me deployer, and this particular act as such will not be applicable to those scenarios. So deployer is a natural or a legal person. It can be a company, it can be a public authority, it can be agency or other body, it can be a human being, that is a natural person using an AI system under its authority. Okay. And here starts the exception. So if you are using it in, for personal use, then that is exempted because, right? So deployer means a natural person that is using AI system under its authority. So a deployer need not develop. Somebody else might have developed it for me. Authorized representatives. So if a company is in India and if they want to develop AI for EU citizens, then you can't completely operate completely remotely from here. Authorized representative means a natural or legal person located or established in the union who has received and accepted a written mandate from a provider of an AI system or a general purpose AI model to respectively perform and carry out on its behalf the obligations and procedures established by this regulation. Simple words. I am a company in India. I want to have my presence in the EU. I can't remotely operate from here and send my AI applications to EU citizens. I need to have my authorized representative where there was a written mandate that was given from me as a provider because I am developing an AI system. So a written mandate has to go from provider that this is the entity, which can be a natural person, legal person, to perform and carry out on my behalf. I am a company in India. Perform and carry out on my behalf the obligations and procedures established by the EU. Questions? All right. Importer. So I'll skip these definitions. They are not as important. Operator. So importer is basically, that entity, natural or legal or whatever. Yes. So if anybody has a question, I'll be happy to. Okay.
Arjun has raised his hand.
Yeah. So sorry, I wasn't able to unmute. So thanks for allowing me to unmute. So, I mean, you showed that risk pyramid slide, right? Can you go back to that?
Yes. Okay.
So you
Yes.
gave some examples of, what could be, like you said, deepfake is transparent limited risk, and you said that social scoring is prohibited.
Right.
So I would like to understand a little bit more about from a startup perspective, right? Of startups who are looking to do business in the EU.
Right.
Like what kind of domains would fall under regulated high risk, and also you said gaming is there for low and minimal risk. I would like to know a little bit more other examples.
Right.
For example, I want to know about healthcare I wanted to know about applications for, say, computer vision in the retail industry, for example, right?
Right.
Or what if it is used, in defense or something? So,
Right. Okay. So then see, these were the important definitions. We need to know who is provider, who is deployer, and these are the two main terms. Once we have talked about these, I think I'll skip these slides. And I think placing on the market, making available on the market are reasonably clear terms. Basically, you are launching your apps in the market now. Okay, it's open for the public to download and so on, start using it. So I'll go to what you were saying. So maybe first I'll answer your question and then come back to what I was doing there. So let's talk about these prohibited AIs. So AI that deploys a malicious use of subliminal techniques. See, these texts are very long. So this is Article 5. So, and Article 5 is pretty long, I think 3-4 pages. So I've tried to just keep, the gist of it. So AI that deploys malicious use of subliminal techniques. Subliminal techniques that they basically, we don't consciously see them, but they impact our conscious. Okay. So, but we don't consciously see them. I mean, we are supposed to be seeing something else. You can look for the examples of, subliminal advertisements. They are also banned in EU and US. So wherever you make a malicious use of subliminal techniques, where we are trying to make a user do something which they otherwise won't do, and we are using subliminal techniques, that thing is prohibited. Malicious exploits of the vulnerabilities of a natural person or a specific group of person due to their age, disability, or specific social or economic situation, that is also prohibited. Evaluation or classification of natural persons or group of persons. So if you want to assign me as 0.1 score because I'm a bad citizen, but if someone else is assigned 0.75 because that person is a good citizen, this is prohibited in EU. You can't make use of someone's age, disability, so special social or economic situation, right? You can't exploit that. AI systems for making risk assessment of natural persons in order to assess or predict risk of natural persons committing a criminal offense. So I'll put it in just one line. Almost everything that is done in law enforcement. So if law enforcement authorities in EU are your clients, then almost everything useful that you would like to do is either high risk or is prohibited, right? So if you want to predict the risk of a natural person committing a criminal offense, that is prohibited. But what is prohibited is based solely on the profiling of natural person. There are details here, but in one line, if I were to say, if your clients are law enforcement agencies, and if you are making an AI that is going to predict the risk of a natural person committing a criminal offense, right? You need to watch out. Because this might be prohibited AI and might have legal consequences. This is, for example, super important because everybody does this. AI systems that create from scratch or expand facial recognition databases through the untargeted scraping. Remember here, keyword is untargeted. Through the untargeted scraping of facial images from the internet or CCTV footage, this is prohibited. Anybody would like to add discussion to here?
Guys, if you want to speak, you can raise your hand or you can drop in your comments or questions in the chat box as well.
Right. So I think this is important. You can't simply go to the internet, scrape all the images, make a facial recognition database out of it. This is prohibited, plain prohibited. You just can't do this, right? But what is important here is untargeted scraping. So if you go to each and every individual, asking them to upload their photos because you want to make a facial recognition database, that's a different thing. What we can't do as a company is an untargeted scraping of facial images from the internet or from CCTV footages. Again, so this I see a lot of students doing in their projects. AI systems to infer emotions of natural persons. This is fine as long as it's a fun activity. But if companies want to do it in the areas of workplace and education institutions, prohibited. Okay. So it's not high risk. It is plain prohibited. Blanket ban on this. Use of biometric categorization. Again, So use of biometric categorization systems that categorize individual natural persons on their biometric data to deduce or infer their race, political opinions, and so on. That is banned. An example of this can be, so for example, if I'm in India, so let's say I have this kind of a system. This is entrance of my restaurant. I have a camera here. Anybody who enters, I, let's say, want to identify whether that person is South Indian or not, or which region in India he or she belongs to. So let's say the family is South Indian. So given that I have understood now a person who belongs to South India has entered, now I can decide to offer them good South Indian dishes like dosa, idli, and so on, right? I don't think we as Indians will call it that bad. But if you see here, the use of biometric categorization systems. So this, based on facial recognition, is a biometric categorization system that categorizes individually natural persons based on their biometric data. Face is a biometric data to deduce or infer their race, political opinions. So in this case, it was race, South Indian. I mean, not race in that sense. Trade union membership, religious or philosophical beliefs, sex life or sexual orientation. If we want to infer any of these things based on their biometric data, this is banned. So, I mean, let's say if we go to Europe, they don't want a restaurant to do this kind of a thing, that if a person from a particular race is coming, I don't want my restaurant to offer them, something specific to them. Use of real-time remote biometric identification system. So this is again for law enforcement. I won't go into this, but real-time remote biometric identification systems are banned. Basically, you can't scrape all airports, railway stations, metro stations in real time to look for one person. There are exceptions to it. But things like if you're looking for some missing person, some victim of trafficking, then you can, but else in general, in almost all the cases, you can't.
Kshitiiz, we have a question in chat if you'd like to answer that right now.
So if inferring emotions using AI is does that mean that chatbot for mental? No. So wait, there is an exception to it. So that's a good question. See, I have not kept, complete details, including the exceptions, but let me take you to the, yes. So this clause F, okay. The placing on the market, putting into service for this specific purpose, or the use of AI systems to infer emotions of a natural person in the areas of workplace and educational institutions. Now, there is an exception that we are talking about, except where the use of the AI system is intended to be put in place or put into the market for medical or safety reasons. So your question, if inferring emotions using AI is prohibited, does that mean that chatbot for mental health would be banned? Not on the, not upfront. So what you are talking about is somewhere covered by this exception, but then it has to be shown that it is indeed covered by this exception. So it's not banned, it's covered by the exception, but anyone has to be more careful. Does that make sense? So it is coming under the regulatory category. It is coming under the prohibited category, but as an exception. So this is an exception. If you want to do something for medical or safety reasons, so for example, I am in a factory, I am deploying a emotion recognition system in my factory, which is hazardous for whatever reasons. And if through the face of my workers there, I infer that this particular, expression is of fear. So then I'm still trying to infer emotions of natural persons in the area of workplace and educational institutions, but it is for safety reasons and hence it is not prohibited. So for example, if in medical reasons, let's say there is no nurse around and a patient has a particular expression, and if you deploy an AI to infer that that particular patient is actually suffering something and is not able to call a nurse or whatever, in that case, that particular application is not prohibited. That is actually allowed. Make sense? Okay. So, all right. So this is the list of prohibited AIs. Now we can go to high risk AIs. Biometrics, we have seen in almost all cases are prohibited. If they are not prohibited, they come in high risk. So remote biometric identification systems, biometric categorization, emotion recognitions, if allowed, that means if they don't come under Article 5, which is prohibited AI, they are still high risk. So the application that you just talk about is not prohibited, but is in high risk AI and has to go through all the procedures. It has to basically make all the checklists that EU AI Act has provided. So not prohibited, but a high risk AI, and hence has to follow the confirmation procedure that the EU AI Act lays down. Critical infrastructure. So road traffic, if anybody is trying to manage road traffic, use of AI in supply of water, gas, heating, or electricity, that is high risk. Allowed, but you have to go through a lot of procedure to make sure that this actually works the way techies want it to work. Educational and vocational training. So if you want to determine access or admission to educational institutions, allowed because it is high risk, it is not prohibited, but so it is allowed, but high risk. Again, that same checks and balances one has to go through. If you want to evaluate learning outcomes, like a couple of days ago, I see in my LinkedIn feed that somebody was making a automated grader for answer sheets. Now, if this were in EU, this was a high risk AI, so it is not banned, but high risk AI that has to be evaluated very rigorously. Monitoring and detecting prohibited behavior during exams and tests. So I can't use AI to, I can, it's a high risk one. So to be able to use AI to detect whether students are, doing cheating in the exams or tests, I have to go through all those procedures. Employment, workers, management, and access to self-employment. So if you are doing recruitment or selection of natural persons, it's a high risk AI. Allowed, you can use AI to in recruitment to select natural persons, right? But it is high risk. That means you have to go through this whole compliance of EU AI. As I said before, EU AI Act basically is for high risk AI. A lot of provisions are there for high risk AI only. That is the main area it covers. So if this is EU's AI Act, most of it is high risk AI. Access to and enjoyment of essential private services and essential public services and benefits. So if you want to evaluate the eligibility of natural persons for such services, for example, I want to have some kind of benefits from the government based on Adhar, the things will come directly into my account. So government, for example, can't use AI to decide the eligibility of natural persons for such services. If I were to be benefited from Ujjwala Yojana, Government of India, if we were in EU, so assuming that, so for example, so if there was a Ujjwala Yojana in EU, governments there can't use AI to decide who will be the beneficiary of it and who will not be. To evaluate the credit worthiness of natural persons. So your CIBIL scores should be, so if you are computing CIBIL scores using AI, that is a high risk AI, and there are a lot of conformity procedures for that. Risk assessment and pricing in case of life and health insurance. High risk AI again. Evaluate and classify emergency calls by natural persons. I am a hospital. I have just one ambulance and one staff to cater. I can cater just one request. I receive 2 phone calls. So I cannot use AI to decide which of these 2 places I will visit. So a human being should make this decision. Or if I use AI, that is high risk, go through all these checks and balances provided by EU AI Act. Law enforcement, almost everything is high risk. I wouldn't, enumerate all of this. I don't think anybody here is from law enforcement. Migration, asylum, and border control management. So I'm not sure, but let's say if you start using in AI in polygraphs or similar tools, high risk. Allowed, but high risk. to assess risk, including a security risk, risk of irregular migration, health risk posed by a natural person who intends to enter or has entered into the territory of a member state. To assess the risk is high risk. And this is important. So it is high risk if you use AI for the examination of applications for asylum, visa, residence permits, and for associated complaints with regards to the eligibility of the natural persons applying for a status, including related assessments of the reliability of evidence. So basically, it is high risk to use AI for processing visa applications or residence permit applications. Allowed, but high risk. Detecting, recognizing, identifying natural persons with the exception of travel documents. This is not complete, so I'll just skip. It is not exactly this. Administration of justice and democratic processes, again, high risk. So if you want to use AI in judiciary, most likely it will be high risk. If you want to use AI system that influences or has some impact on elections or outcome of elections, that is high risk too. So I'll again take a break here and let me see if there are questions, because I would like to cover this slide as well. We have not talked about these two slides. So maybe I'll keep these two slides as my last slides, unless you have questions before that. Okay. So the Article 2 talks about the scope of the regulation. This regulation applies to providers placing on the market or putting into service AI systems, or placing on the market general purpose AI models, basically foundation models, big models like ChatGPT in the Union, irrespective of whether those providers are established or located within the Union or in a third country. So if providers placing on the market, putting into the service in the Union, irrespective of whether those providers are established or located within the Union or in a third country. So if you are placing your AI for use in the EU market, it does not matter whether where you are established or located, within the Union or in a third country. The regulation applies to you. So if I am an Indian company, I want to do some AI for EU residents. Residents it is, not citizens. If EU residents, then basically it is high risk AI. Sorry, not high risk AI. This particular regulation is applicable to such companies. The moment I want to place something on EU market, this act comes into picture by default. It does not matter my company is established or located in India, China, or anywhere else. So these are providers, those who basically develop AI systems or get them developed. Deployers of AI systems that have their place of establishment or are located within the unions. So providers can be anywhere on the earth. Deployers, they have to be in EU. So deployers of AI system that have their place of establishment or are located within the union. Okay. Providers and deployers of AI systems that have their place of establishment or are located in a third country where the output produced by the AI system is used in the union. So this particular provision is to, stop basically circumventing the law, because so providers and deployers of AI system have their place of establishment or are located in a third country, but where output produced by the AI system is used in the union. So for example, what can happen? A deployer that is in EU contracts with a company that is in India, because this company will be taking input from me, will give me output. So all the processing has happened in India and output is sent back to EU, right? If this provision was not there, one can come and say, see, deployer is in EU, provider is outside EU, but is not putting any service or placing, is not putting any service on the AI systems or placing anything on the EU market. There is a deployer that is receiving that output from an Indian company and placing it on the market. So this basically provision kind of takes care of this fact that you can't contract. So as a deployer, I can't hire a company or outsource my work to a company in India. They will do all the work, give me the output, and I will use that output. No. Output produced by the system, if it is used in the union, it is applicable again. So this kind of arrangement will not work. Importers and distributors of AI systems. I have not talked about what are importers and distributors, but they are in the supply chain. If they are not basically, main provider or deployers, they basically import product and under their own name or trademark. So authorized representative of providers, this is an important thing. If you are an Indian company and if you don't have your presence in the EU market, this is what you will require, because it is for those which are not established in the union and the affected persons that are located in the union. So in all these cases, EU AI Act applies. Any questions on this slide? If you are thinking of going to EU market, I think this slide is very important for you. So question is, so if the compliance of these categories like emotion recognition, traffic management, credit worthiness, recruitment, risk assessment, etc. is 300k euros once in force, then startup working in these cases should account for this budget. No. So see, to be honest, I have no idea how they computed this 300k euros, right? I have just read it somewhere, but that was a news. So the EU lawmakers, they recognize this, and what they have done is they have allowed the use of, so they've created some sandboxes. So there will be something called EU AI office, and that's also in very much news. So under these administrative, under this regulatory framework, there are sandboxes where companies can go talk to these regulatory agencies and, let's say, discuss things like, see, what we are doing might be a high risk thing, right? And we want to develop it in a safer environment. So I want to develop those things that are high risk AI. I don't want to directly go to the market. So you work in those sandboxes, and where you are in, continuous, where we are taking continuous feedback from these regulators, and you finally place your thing on the market, because kind of it is assumed that now you have gone through all the checks and balances, but that's a pain anyway. So, and these are ongoing debates that the regulatory compliance of these things are, the compliance cost of EU AI Act is actually too high. But from of late, what I have been reading in the news, both in tech and legal side, I think this will eventually happen for almost all jurisdictions in one way or the other. Like GDPR is a very bulky regulation. Initially, India, when so India started its first version of GDPR on the DPDP Act on I think sometimes in 2018. Now the 2019 version was almost a verbatim copy of GDPR. It had 99 sections. It was very lengthy, but eventually that was passed. Was just, I think it had 30 sections. Our own version of GDPR, which is the Digital Personal Data Protection Act. The rules are still yet to be out, but so Indian government realized that we are still a developing economy and we can't be as strict and stringent as EU is, because we want our startups to flourish. So there was greater balance between the rights of the citizens and development of companies and economy. So I think even this EU AI Act in some or the other form will be eventually applicable in India too. But I think the same approach will be followed here as well. Probably much lesser stringent, much lesser stricter than what it is in EU. But from what I understand, it is coming. Today, tomorrow, 5 years down the line, 5 years will be too late, but it is coming. I think once we have all these elections are over, we might see something on these lines in India too. I don't know if this answers your question, Arjun. Okay, so probably my last slide. So it does not apply outside the scope of EU law. So it does not apply to, for example, any Indian company unless it falls into any of these categories. It does not apply to military, defense, or national security purposes, public authorities, or in a third country, nor to international organizations. It is not applicable. So these things are important. It is not applicable for the sole purpose of scientific research and development. This is important. So academic research is kind of exempted. But there are, this is a reasonable exception in the sense that still one can't do each and everything that they want to do. Whatever they are doing must be lawful from other laws too. Does not apply to any research, testing or development activity that happens prior to placing on the market in accordance with EU law, and testing in the real world is not covered in this exception. So you can test in your own company, and unless you make it available on the public, unless you test it in the real world, you can test, and that until there it is exempted from the purview of the act. It does not apply if it is so as to decrease the consumer rights and safety in whatever way. To natural persons using AI systems in the course of a purely personal, non-professional activity, so that is also exempted. I as a person, if I want to use an AI for some personal use, that is fine. Personal, non-professional activity. So as to preclude member states from making laws favorable to workers. So I will not take up this. AI systems, so again, this is of importance again. AI systems released under free and open source licenses, except that fall in the first three categories of the pyramid. So AI systems released under free and open source licenses, they are exempt from this, but those things should not be prohibited, high risk, or the third one, for which there is a transparency requirement. There's a new notion that this act introduces. This is AI literacy, and almost every company should have that. So, but anyway, I'll not go into this. Maybe I'll stop here and take up if there are any further questions. So how do we get in? So that is stupid of me. I'll share, so are we sharing this link to Google Slides with them?
We don't plan to share the presentation, but if people want, maybe we can.
Okay. So, okay, I'll share it on my LinkedIn as well. Yeah. So there's a question: can EU Act enforcement lead the Indian government to make the rules strict? I don't think so. Right now, I see there's a race. There's a race, particularly across Atlantic. So EU, there's a lot of dialogues exchanging between the EU and the US. To some extent, Brazil is also following all these things pretty closely, and they are also coming up with their own laws. China has already in place, but they are, I think, I wouldn't say much, because the values that China allow is in some cases very different from what, let's say, EU has allowed. So can EU Act enforcement lead to the Indian government to make strict rules early? I think once elections are over, I expect to see something around it. But I think it is very important to acknowledge two things. One, that AI is super overrated. It is super overrated. Just by saying that accuracy of my system is 95%, on the ground, it almost does not mean anything. And second, ethical considerations are super important, because in the end, when cases go to court, so for example, in US, there is this big debate going on whether generative AI should be an exception to copyright law. But EU AI Act has clearly said it is not an exception, and every foundation model, every general purpose AI has to respect IPR.
I think we've addressed all the questions here.
Yeah.
Right. Thank you so much, Kshitiiz. Really appreciate this. And everyone who's attended and stuck to the end, I hope this was very useful. Please share your feedback and suggestions on what kind of further topics would you like to cover. Thank you so much, guys.
Okay. Chalo, thank you
Bye.
for, yeah.